Welcome to another special session on corporate law CL4 aimed at answering your questions in the examination. This is based on the mock paper provided by the Institute of Chartered Accountants of Sri Lanka, and during my last session, I discussed certain MCQ and structured questions, and today I am going to continue with the rest of the paper, the mock paper, and I would like to tell you that this mock paper is very similar to the type of examination question paper that you are going to receive at your examination. Therefore, it would be very important for you, it would be very relevant for you to follow this lecture and learn how to answer the questions given. So, today I would like to start with a structured question. In question number 2 that we discussed, already we discussed question number 2 part A, and today I would like to start with part B of question number 2. Now, the question reads as, according to the Articles of Association, the object of AB Company Limited is manufacturing and exporting garments. Due to COVID-19 pandemic, the company has no sufficient raw materials to perform their manufacturing process. Therefore, the board of directors has decided to manufacture hand sanitizers for the local market, even if it does not comply with the above objects of the company. And you are required to explain whether AB Company Limited can engage in a transaction of manufacturing hand sanitizers by considering the relevant provisions of the Companies Act number 7 of 2007. Now, you would see that this question carries 5 marks. So, I would like to provide you a very comprehensive answer covering all the relevant areas in this question, but you may decide in answering your question in your question paper how long you would like to provide the answer. But I would rather advise you to provide the maximum possible length, since you can get the maximum marks of 5 if you provide a very comprehensive answer. So, this is what actually today I am going to do, to provide you a very comprehensive answer to this question and to all the questions that I am going to discuss today. Now, if you go back to the question, what the question poses to you is that according to the Articles of Association. Now, what is Article of Association? I have told you last time, as well as you know during the lecture series, and now you have a very good understanding that it is a part of the constitution of a company, and this is a very important document, because this document, Articles of Association, is the one that runs like the vein of the company, and it discusses all the relevant things and matters that need to be fulfilled in performing the business activities of a company. Now, here the object of AB Company Limited, right? So, this is a company where Articles of Association in the object clause, because generally the Articles of Association commences with the object clause, that is to say, what are the objects for which this company has been formed. So, here it is manufacturing and exporting garments, So, the object has been manufacturing and exporting of garments, the apparel industry. But due to COVID-19 pandemic, the company has no sufficient raw materials to perform their manufacturing process. Now, even right now, we are in the middle of this COVID-19 pandemic, and we know numerous businesses have faced numerous issues in engaging themselves in the normal activities that they are engaged in their business processes. So, likewise here the AB Company Limited has also faced difficulties in manufacturing and exporting garments due to scarcity of sufficient raw materials being available for them to make the apparels. So, what they do now is that board of directors of that company, AB Company Limited, has decided to manufacture hand sanitizers instead, because the hand sanitizers have a big demand right now with the COVID-19 pandemic. So, they have thought of shifting their business of manufacturing hand sanitizers for the local market. So, it is not even export market, it is for the local market. So, this is how you see that the purposes or the objects vary significantly, that the original purpose of the company is to manufacture and export of garments or apparel. But now what they are trying to do, or pursuant to the decision of the board of directors, to manufacture hand sanitizers for the local market. So, this is extremely different from their original purpose according to the articles of association. So, even if it does not comply with the above objects of the company, the director board has decided so. Now, what we have been asked to do is to require to explain whether AB Company Limited can engage in a transaction of manufacturing hand sanitizers by considering the relevant provisions of the Companies Act number 7 of 2007. Now, if you look at the answer that I have given, as I mentioned to you earlier very comprehensively, let me first of all explain and analyze what this objects of a company means as per the articles of association. The objects of a company as outlined in its articles of association are vital and integral to its existence. Any operation which is not compliance with its objects is considered invalid and form an act of ultra vires. Unless a company's article specifically restricts the objects of the company, its objects are unrestricted. This occurs when the articles have taken a general approach, allowing a company to do whatever possible in its generality of application. But it is always not the case, especially when the articles have restricted its objects or have taken a defined scope. Therefore, unless certain amendment has taken effect to suit a relevant exercise, a company's business activities, inclusion of an activity that falls outside the company's object become null and void, as well as an act of ultra vires. Where a company amends its articles so as to add, remove or alter a statement of the company's objects, it must first of all give notice to the registrar of companies, and on receipt of the notice the registrar shall register it, and finally the amendment is not effective until entry of that notice on the register. So, what I have done in this answer first and foremost is giving an overview of what purposes or objects of a company really means as per the articles of association. Now, in the case of Ashbury Railway Carriage and Iron Company versus Ritchie case, this is a very landmark case where it comes to the object of a company. It's a classic examples of this area. This was a case where the Memorandum of Association forming the Ashbury Railway Carriage Company stated that its objects were to make and sell or lend on hire railway carriages, and further that activities beyond the stated objects need a special resolution. That is what the Articles of Association of the Ashbury Railway Carriage Company stated. However, the company agreed to give a loan to Richer and his brother to build a railway from Antwerp to Tournai in Belgium, but later the company repudiated the agreement. The House of Lords held that the company has pursued objects beyond its scope provided by its Memorandum of Association, and such actions are ultra vires and void. Therefore, the agreement entered with Richer and his brother is void as far as the company is concerned. Acts of ultra vires include acting in excess of power, acting in abuse or breach of power, and acting with lack of power. Now, also in Cotman versus Brougham, the relevance of a company's object was highly dealt in. This was the case concerning the objects clause of a company and the problems involving the ultra vires doctrine. It held that the clause stipulating the courts should not read long lists of objects as subordinate to another were valid. This case is now largely an historical artifact, given that New Companies Act no longer have to register objects under the Companies Act 2006 section 31 in UK, and that even if they do, the ultra vires doctrine has been abolished against third parties under section 39. It is only relevant in an action against a director for breach of duty under section 131 for failure to observe the limits of their constitutional power, or what has been mentioned in the Articles of Association. Now, according to section 17(1) of our Companies Act number 7 of 2007, where the Articles of a company sets out the objects of the company, there shall be deemed to be a restriction placed by the articles in carrying on any business or activity that is not within those objects, unless the articles expressly provide otherwise. Section 17(2) further provides that where the articles of a company provide for any restriction on the business or activities in which the company may engage, the capacity and the powers of the company shall not be affected by such restriction, and no act of the company, no contract or other obligation entered into by the company, and no transfer of the property by or to the company shall be invalid by reason only of the fact that it does in contravention of such restriction. This is entirely within the decided common law case of Ashbury Railway Carriage and Iron Company versus Richer as described above. Now, if I may stop there, you see, when I started answering this question, I gave an introduction to what really objects of company mean as per the Articles of Association and gave an outline of that. And then I went in to discuss the common law situation that prevailed earlier and getting back to our statutory law, which is the Companies Act number 7 of 2007. Now I try to analyze and argue on how we are going to come to the conclusion of the question, the answer rather. So I mentioned that, however, it should also be noted that in the case the company has acted against the objectives or in lack of prevailing objects in utilizing a different purpose, then the directors would become liable for acting in ultra vires, because the action would be against the directors who have taken such a decision to deviate from the purposes provided in the Articles of Association, thus absorbing some new objects into it. So this is explained in section 17(3) as nothing in subsection 2 or the previous subsection shall affect the ability of a shareholder or a director of a company to make an application to the court under section 233 in obtaining a restraining orders to restrain the company from acting in a manner inconsistent with a restriction placed by the articles unless the company has entered into a contract or the binding obligation to do so, or the liability of a director of a company for acting in breach of the provisions of section 188 that relates to the director's duty to comply with the articles. So, I explained there in conclusion how this matter would really be falling within the meaning of our law, the Companies Act number 7 of 2007. So, therefore, in light of these things as I outlined, you need to provide your answer so that your examiner will be confident that you have understood the real contents of the question and you have arrived at a conclusive answer that clearly set out the argument that you have developed. So, this is how you need to give a proper and comprehensive answer to the question. This would, I am sure, going to give you total of 5 marks that question has set out. Now, let us go to question number 4. In question number 4, the total is 10 marks, but you will see that it has 2 parts. Now, this new system of examination paper at chartered accountants is different from the previous old system, because in the previous papers I have seen that the laying out is different from what you are getting this time. So, that is another area that you need to pay much emphasis on answering your question paper. Now, you know that all these 7 questions are compulsory for you to answer. So, you need to provide answers to everyone, but I would say as a experienced lecturer, trainer, as well as a person who has faced many examinations, in order to build confidence in your examination, you must first select the best questions that you are more comfortable with. You select the most easiest question first. Then by answering that, you will develop a lot of confidence in you, because it is not to say that always in a question paper, when we get the question paper, we become very nervous. But with the way that we write our answers, we either develop confidence and progress very efficiently, or we panic that we cannot answer a particular question, and then the entire paper is disrupted due to our non-confidence in answering. So, that is what I am saying, that it is very important for you to answer the most easiest questions first and then go gradually to the difficult questions. In your answer sheet, you are not required to answer in order of the questions. So, you can decide if you want to answer question number 2B first. It is at your liberty. Then say taking question number 5, answer B. Then going to question number 6, answer A or C, likewise. So, it is up to you to decide the sequence. So, my advice is that you should select the sequence based on your own confidence that you have with regard to the questions that you get in your question paper. Now, with that, let me go to question number 4, part A, and it also carries 5 marks for you out of 10 total marks given to the entire question number 4. It carries 2 parts, A and B. Now let us attempt to answer part A. Now in 2015, a private company was duly incorporated under Companies Act number 7 of 2007 by name of Strong Cement Private Limited. The directors of the company came to know that on 31st of March 2020, another company has published a public notice by name Strong Cement Limited. The directors of the first registered company Strong Cement Private Limited opposed to the name of the secondly registered company. So what you are required to advise the first registered company, which is Strong Cement Private Limited, registered in 2015, how it can prevent the secondly registered company from using the word strong cement in its name according to the Companies Act number 7 of 2007. Now my answer here is that I provide again a very comprehensive one. In registering a company, the Companies Act number 7 of 2007 requires that the application for registration, when you apply for registration of a company, it must state, the application must state, the company's proposed name. It starts there. But generally, before someone register a company's name, you need to do a company name check with the company registrar, ROC. If your name is clear, approved, that there is no existing company and your name can be obtained from the ROC, then you can proceed to the next levels of applying the application for its registration. Then also you must state whether the company's registered office is to be situated, where the company's registered office is to be situated, the address, because the registered office address is a very important thing. That is where the company is going to rest officially and legally. Then thirdly, whether the liability of members of the company is to be limited, and if so, whether it is to be limited by shares or by guarantee. So what is the nature or style of the company's liability? Whether it is limited, if it is limited, then is it limited by shares or limited by guarantee? And whether the company is to be a private or a public company. So these are the more fundamental characteristics of a company that one must tender with the application for registration, so that the registrar of company gets a more primitive idea what the company is going to be. Therefore, it is clear that the first and foremost requirement in registering a company is to name that company in the proper way. So name is a very first and foremost requirement. Now section 2(1) of the Companies Act requires that a company incorporated under this Act, Companies Act, shall by the name by which it is registered from time to time be a body corporate. So it is by the name that the company is going to be a body corporate. Under section 7(1), a company shall not be registered by a name, shall not be registered by the ROC by a name which is identical with the name of any company or of any registered overseas company. Right? So where the company's present company that seeks registration, its name is identical with the name of any other company that is existing or of any registered overseas company. So now suppose that there is a company overseas but which is not registered in Sri Lanka, then you can take that name, no issue. But if your company name is identical to the name of another existing company in Sri Lanka, so registered, or another registered overseas company, then you are not supposed to get that name. Also, the name that contains the words Chamber of Commerce, you cannot take, unless the company is a company which to be registered under a license granted under section 34 without the addition of the word limited to its name. That means where the license of registering as a Chamber of Commerce has been also obtained. Or is in the opinion of the registrar misleading. The name is misleading, probably with an existing name. And further, according to section 7.2, no company shall be registered by a name which contains the words president, presidential, or other words which in the opinion of the registrar suggest or are calculated to suggest the patronage of the president or connection with the government or any government department. Also, the term municipal or incorporated. Now, generally the name incorporated is obtained by statute, by legislation passed by the parliament, or other words which in the opinion of the registrar suggest or are calculated to suggest connection with any municipality or other local authority or with any society or body incorporated by an act of parliament, such as the Incorporated Council of Legal Education, for example. Then the names cooperative or society cannot be obtained, or national, state or Sri Lanka, or other words which in the opinion of the registrar suggest or are calculated to suggest any connection with the government or any government department. However, use of the words the, company, and company, company limited, and company limited, limited, unlimited, private limited, public limited company, type and case of letters, accent spaces between letters and punctuation marks and or n are not considered as prohibitive. So, all those things can be obtained to name a new company. Now, if the name of a company is identical or similar to an existing name of a company, like in the case that this question poses, the first registered company must request the registrar of companies within 3 months, the timeline is 3 months, from the date of the second company's public notice to change the name of the secondly registered company. So, the first registered company having the identical name must take action to object to the name of the second company seeking the registration in the same name to the registrar of companies, and such objection must be made within 3 months from the date of the second company's public notice to change the name of the second registered company. Then the registrar may direct second registered company to change its name. If the registrar sees that this is identical, then the registrar will direct the second registered company to change its name, because there is a company existing right now with similar identical name. Thereafter, the company must change its name within 6 weeks. If that second company seeks to retain its application with the ROC, it must change the name within 6 weeks from the date that the ROC has informed that second company that they cannot have this name from the date of issue of such direction. If the second company fails to comply with the direction, the company shall be guilty of an offence and on conviction be liable to pay a fine not exceeding 200,000. That means a maximum of 200,000 rupee penalty to be paid to the ROC. to the court for such a thing. Shall be guilty of an offence and on conviction. That is, that then the company ROC, the register of company, must go to court and file action against the second company for failing to change its name, and the court can fine that second company to a maximum of 200,000 rupees. Now I come to the conclusion of the answer, where I state that in view of the aforesaid, no company having a similar identical name as given in this question shall be registered by the Register of Companies as a new company, as there prevail an existing company with such type. Therefore, the already existing company must take action to inform and object to the ROC on the disallowing or a strike off of the second company's name. If the registration has been made effective, then the name of the new company having similar identical name. So this is how I come to the conclusion of the answer, and you are also required, find after clarifying the status of the legal situation, to arrive at your conclusion of how you hold the question posed in your answer by giving the finality. Now, question number 4, part B, also carries 5 marks, if you can see at the end. Now, the question is, Amal and Bimal are going to form a company subject to the following conditions. The company should be incorporated under the Companies Act number 7 of 2007. The company will engage in a business of selling pharmaceutical products in Sri Lanka. The company must have a share capital and they must be shareholders of the company. The ownership of the company must be restricted only among the 2 of them. Amal and Bimal want to safeguard their personal assets in the event of future liquidation of the company. So what you are required to do is required to analyze the different types of companies recognized by Companies Act and advise which type of company is best suited for the above condition. Now, if you see, this is again a different style of a question, because the question here is where you determine, considering the different types of companies that can be created under our law, what exactly the company that suits the wishes of Amal and Bimal, and the wishes or the intentions are described in 1 to 5 Roman numericals. So, you don't have to answer one by one separately, but you must give first of all a clear analysis of what type of companies can be created under our law. So, therefore, I approach the answer by explaining what type of companies that can be created under our law and what are the relevant sections that makes such proviso and limitations or exceptions. So, in doing so, I say there are different types of companies that can be set up under the prevailing law of companies in Sri Lanka. These include private companies that are created by private individuals and or other private companies, either private individuals or by private companies or a mixture, to attain private goals. So, they are not public goals, but private goals set out in their constitution, articles of association. And public companies, on the other hand, that are created by state or the government to serve general public or a private company reaches the threshold, either to serve the general public or where a private company reaches the threshold of being listed as a public company. So that such a company that comes to a certain level of its turnover no more be called a private company, but it is to be considered and converted into a public company for the public good. One such example is Odell, for example. Odell Private Limited, which was owned by Ottara Gunawardena as the principal shareholder there, was later came to a situation that its turnover passed the threshold of being a listed company. So at that moment it was converted into a PLC, public limited company, and listed in the stock market, so that anyone in the public can buy shares through the stock market and invest in that company. So public companies are such that it is either created by state or the government to serve general public purposes, or a private company that reaches the threshold of being listed as a public company. Then the third category of companies are called guarantee companies, that are created with the aim of providing guarantee at the inception of the company, so that the shareholders don't have to pay for the shares, but they guarantee to provide the amount for their shares if that guarantee company comes into a situation of a liquidation or dissolution, to hold liability of shareholders at a time of closure or bankruptcy. Now, according to section 3(1) of the Companies Act number 27 of 2007, a company incorporated under this act may be either a company that issues shares, the holders of which have the liability to contribute to the assets of the company for the number of shares that they obtain, if any, specified in the company's articles as attaching to those shares. In this act referred to as limited company or limited liability company, because the liability is limited to the extent of the shares owned by a particular shareholder. So at a time of a closure due to bankruptcy or any other purpose, any other concern, the shareholder has to only contribute to the share value. Or the second category, a company that issues shares, the holders of which have unlimited liability to contribute to the assets of the company under its articles, or that are referred to as unlimited companies, where the liability is unlimited, so that it would not be limited to the number of share or the share value of a shareholder, but the liability of the shareholder is unlimited, where in a case of a bankruptcy, that shareholder will have to even bring his personal assets in settling the company's debt. So this is a very risky situation. Or the third one is a company that does not issue shares, the members of which undertake to contribute to the assets of the company in the event of its being put into liquidation in an amount specified in the company's articles, and this is a company limited by guarantee, where at the inception of the company, the shareholders give a guarantee that in case the company runs into a liquidation, such as bankruptcy, they will contribute to the number of shares that they have taken out from the company. So, based on the liability aspect, A company can be a limited liability company, a company can be an unlimited company, a company can be limited by guarantee. So, now we have covered public company, private company, guarantee company, and with regard to limitation of liability, limited liability company, unlimited liability company and guarantee company. Now, why we are doing this exercise is in order to find the best solution for Amal and Bimal to start the company that they prefer, because there are so many situations posed to us from Roman 1 to Roman 5 I showed to you earlier. Those are the concerns of Amal and Bimal in identifying what is the best solution for them. Now, as per section 27, section 27, it is prohibited for a private company to offer shares or securities to the public, because by virtue of being a private company, they are only expected to issue shares or call for shares from private individuals, and number of shareholders should be within 2 to 50. So, minimum of 2, maximum of 50 individuals or body corporate or a mixture, other than employees or ex-employees who have secured shares by being employees. So, that number does not fall to suit where there are employees for whom the shares have been issued, because they fall into a very special category of shareholders. That is the reason. So, generally shareholders holding ordinary shares must consist of at least of 2 or maximum of 50 persons or individuals or body corporates or mix. Now, with regard to public companies, they shall have at least 2 shareholders, unless in case of a state. If a state is going to create a public company, then the minimum requirement of 2 shareholders can be replaced by a single shareholder, and this single shareholder, who is the secretary to the treasury holding shares on behalf of the government, can create such a company. In such a case of a guarantee, in the case of a guarantee company, there shall be minimum of 2 shareholders, and the maximum is not mentioned. So, there can be any number. With regard to the nature of a company, that means with regard to the liability of shareholders may differ. Limited liability, according to section 3.1, a company that issues shares, the holder of which have the limited liability to contribute to the assets of the company, if any specified in the company's article as attaching to those shares. For example, ABC Limited, that is a public company, ABC Private Limited, which is a private company, and ABC PLC, a public quoted or listed company. While in case of unlimited liability company as per section 3.1b, a company that issues shares, the holders of which have the unlimited liability to contribute in case of a bankruptcy or closure to the assets of the company under its articles, as for example ABC Unlimited, which is a public company, and ABC Private Unlimited, which is a private company. Now, here we are here in relation to a guarantee guaranteed liability, section 3(1)(c). It states that a company that does not issue shares, the members of which undertake to contribute to the assets of the company in the event of being put to liquidation in an amount specified in the company's articles, for example, ABC Guarantee Limited, which is a public company, and ABC Guarantee Private Limited, which is a private company. As stated by Farwell J. in Boland's Trustee vs. Steele, which is an English case, a share is the interest of a shareholder in the company measured by a sum of money. Can be like 10 rupees, for example, for the purposes of liability in the first place and of interest in the second. Liability on one side, interest on the other for the shareholder, but also consisting of a series of mutual covenants entered into by all the shareholders, their undertakings. Considering the given question, now we come to the conclusion. Considering the given question, as per item 1, item 1 was that Amal and Bimal wants to know the company should be, they are interested or concerned that the company should be incorporated under Companies Act. So, in providing clarification for that, it should be a company coming under the Companies Act. Only the companies that are being permitted under our Act that Amal and Bimal could create. Therefore, it should belong of the aforementioned categories that I explained to you: private, public, or guarantee, and being limited, unlimited, or guarantee. But Amal and Bimal being private individuals, obviously they will have to go for a private company. Now, with regard to item 2, item 2 is the company will engage in a business of selling pharmaceutical products in Sri Lanka. So, it is a business company, business oriented or profit oriented company for sure. So, with regard to item 2, the business of the company must be legally valid, or the purposes for which the company is to be created should be valid ones. As pharmaceutical companies are not prohibited to be created unless otherwise, the necessary approvals also should be obtained from the Ministry of Health in Sri Lanka in order to carry out its business. As the purposes are purely private in nature, and it appears that Amal and Bimal would want to carry out a private business, it would most probably a private company. Further, in consideration of item 3, now let us look at what is item 3, that they want that the ownership of the company must have a share capital and they must be the shareholders of the company. Then, considering that, what we arrive at is that it is clear that the only shareholders of the company are to be Amal and Bimal, and with the requirement of 2 minimum, they can do it at inception, and therefore, the minimum requirement of having a private company can well be fulfilled. If both of them are to match item 4 requirement thereafter, what is item 4? That the ownership of the company must be restricted only among the 2 of them. Then the liability of the shareholders Amal and Bimal are meant to be of limited characteristic. The ownership of the company must be restricted only among the 2 of them, which means then it should be a private company, because the minimum number of 2 suffice there. Then fifth one is Amal and Bimal want to safeguard their personal assets in the event of future liquidation of the company. This is a very important concern of many people who are forming companies, because as you know that company is a distinct and separate person having its own legal personality. So as long as the company is limited by shares of Amal and Bimal, their personal or private property won't come into the liability of the company, as long as there is no act of ultra vires by which the corporate veil would one day be lifted by the court. So therefore, the shareholders are meant to be of limited characteristic. This would mean that private company be limited in liability. Therefore, ideally it should be a company having a name. So what's the name that they are going to have, right? What's the name that they are going to have to the company, and followed by private limited. So it's not a guarantee company, because you know that it's a profit making business that they are going to make, pharmaceutical, and it's not a public company. So therefore it should be a private limited company. Now let's go to question number 5. Now here the style and structure are different from the previous ones that we discussed. Why I am saying that is that the question 5 carries 4 parts: part A, part B, part C and part D. 4 parts. And each of the parts carry equal amount of marks, which is 2.5 marks per part. So 2.5 into 4. And then totally for question number 5 having 4 parts, you are going to get total of 10 marks. 10 marks. Now let's look at part A. The question is, Mr. Anthony, a promoter of a company, is going to engage in transactions on behalf of the future company, and you are required to explain the legality of such transactions and responsibilities incurred to the promoter of such transactions under Companies Act number 7 of 2007. Now, by now you know who is a promoter. Promoter is a person who promotes the incorporation of a company or setting or creating a company prior to its registration or incorporation. And the promoter with a prospectus promotes the idea of setting up this company and canvass for the investments that it needs for the company to set up. So therefore, the promoter acts privately by himself prior to the incorporation or creation of a company. But however, the promoter is at that time acting on behalf of the company that is to be formed. But what is significant there is that there is no existence of a company. What he is representing or what he is representing on behalf. So therefore, the legal situation is very, very strange here. So in answering, I have provided a very comprehensive answer yet again. And here I say, we should first see who is a promoter. need to give a certain clarification in order to enter into our answer. As per section 41(6) of the Companies Act number 7 of 2007, a promoter means a promoter who was a party to the preparation of the prospectus, because at the time of making the prospectus, the promoter's intention is to make the company that is to come in the future attractive to the investors that he is seeking the investment from. So, he prepares the prospectus or of the portion thereof containing the untrue state, because there is no existence of the company. But the promoter is taking a huge burden there, that he puts in the prospectus what may come out to be in the future, but which are not yet true, but does not include any person by reason of his acting in a professional capacity for persons engaged in procuring the formation of the company. But a lawyer who is preparing the documents for a company, or an accountant who is preparing certain projected incomes of financials of the company, are not considered as promoters, because what those lawyers and accountants are doing are professional work in their professional capacity. But promoter is a different person, that he is more engaged in promoting his idea, seeking the investment for the company itself. So, such a promoter is engaged in bringing up a company by promoting it among prospective shareholders in order to attract them to purchase shares prior to a formation of such a company. In doing so, the promoter engages himself in entering into what we call pre-incorporation contracts. Now, that also comes into this area. The contracts that a company is really not entering, but a promoter is entering on behalf of a company. So, these contracts are called not company contracts, but pre-incorporation contracts. The law is that when a company comes into existence, all those pre-incorporation common contracts need to be ratified by that company. Otherwise, those pre-incorporation contracts are not valid, because the company has not ratified such contracts. So, pre-incorporation contracts that he enters, or the promoter enters on behalf of a company to be established. So, it is the promoter who enters into these pre-incorporation contracts. Here the promoter is going to engage in transactions on behalf of such future company. Generally, the promoter enters in his own name, but stating that he is doing so on behalf of the company to be established in the future, or the future company. So, this is a very tricky situation in company law. Therefore, the pre-incorporation contracts are those contracts purported to be made on behalf of a company, entered before the incorporation of the company. These are generally brought about by the promoter, who intends the formation of such company, who is thereby obligated to bring the company in the legal existence and to ensure its successful running. And in order to accomplish his obligation, he may enter into some contract on behalf of prospective company. The contract that he enters with a third party is not the contract that he enters for himself, but on behalf of a company, but however, that company does not exist still. So, therefore, this is not only that it is very dangerous, but extremely risky, because as I told you earlier, if the future company, once it comes into existence, does not ratify the pre-incorporation contract that the promoter entered into, then the promoter runs the risk of being personally liable. Nature of pre-incorporation contract is slightly different to ordinary contract because of that. Nature of such contract is bilateral between two parties, be it has the features of tripartite contract sometimes. In this type of contract, the promoter furnishes the contract with interested person, and it would be bilateral contract between them. But the remarkable part of this contract is that this contract helps the prospective company who is not a party to the contract. But whereas the promoter is entering on behalf of that prospective company. As per section 223(1) of the Companies Act, the expression pre-incorporation contract means a contract purported to have been entered into by a company before its incorporation, or a contract entered into by a person on behalf of a company before and in contemplation of its incorporation, either category, as recognized by the Companies Act. Further, section 23(2) states, notwithstanding anything to the contrary in any law, a pre-incorporation contract may be ratified within such period as may be specified in the contract that is originally entered between a third party and the promoter, where the promoter acts on behalf of the company, or if no such period is specified, then within a reasonable time after the incorporation of such company. So, that is called the ratification process, in the name of which or on behalf of which it has been entered into by the promoter. So, a pre-incorporation contract that is ratified shall be as valid and enforceable as if the company had been a party to the contract, such as in the case of a company contract, similar to that of a contract entered by a company after its incorporation, at the time it was entered into. And such ratification is valid when it is ratified by the company in the same manner as the contract may be entered into on behalf of a company. So, once the contract is ratified, the validity attaches to the real beginning of that contract at pre-incorporation status, where the promoter has entered into of a future company. So, it is valid from that beginning. If the company fails to ratify or does not ratify, what happens then? The promoter becomes personally liable. In pure common law sense, pre-incorporation contract does not bind company as held in Kellner versus Baxter. It is a very old common law situation. In this case, a group of company promoters for a new hotel business entered into a contract purportedly on behalf of the company which was not yet registered to purchase wine. Once the company was registered, it ratified the contract However, the wine was consumed before the money was paid, and the company unfortunately went into liquidation. The promoters as agents were sued on the contract. They argued that the liability under the contract has passed by ratification to the company and that they were hence not personally liable. It was held, however, that as the company did not exist at the time of the agreement, it would be wholly inoperative unless it was binding on the promoters personally, and a stranger cannot by subsequent ratification relieve them from that responsibility. As held by Earl C.J., as there was no company in existence at the time, the agreement would be wholly inoperative unless it were held to be binding on the defendants personally. Now that was the old common law situation. In Newborn versus Sensolid, Great Britain, it was held that the signature and the contractual document will be a complete nullity because the company was not in existence. Cogburn C.J. in Twycross versus Grant observed that the promoter is one who undertakes to form a company with reference to a given project and to set it going, and who takes the necessary steps to accomplish that purpose. The promoters are therefore generally held personally liable for pre-incorporation contract. If a company does not ratify or adopt a pre-incorporation contract under the Specific Relief Act in England at that time, then the common law principle would be applicable that such company will not be liable for that pre-incorporation contract, and the promoter will be liable personally for breach of contract if such a pre-incorporation contract was not ratified under Specific Relief Act. The position has now been altered in Sri Lanka's company law and also in UK, because the common law decision has now been overtaken by the legislation, the Companies Act. According to section 23, for the purpose of this section and sections 24 and 25 of this act, the expression pre-incorporation contract means the statutory meaning of a pre-incorporation contract is that it is a contract purported to have been entered into by a company before its incorporation, or a contract entered into by a person on behalf of a company before and in contemplation of its incorporation. Either of these two would fall within the meaning of pre-incorporation contract. Now, as per section 23(2), notwithstanding anything to the contrary in any law, a pre-incorporation contract may be ratified within such period as may be specified in the contract, or if no such period is specified, within a reasonable time after the incorporation of such company, in the name of which or on behalf of which it has been entered into by the promoter. According to section 23(3), a pre-incorporation contract that is ratified under subsection 2 shall be as valid and enforceable as if the company had been party to the contract at the time it was entered into. Further, section 23(4) states that a pre-incorporation contract may be ratified by a company in the same manner as a contract may be entered into on behalf of a company under section 19. So, relying upon that former English law situation of applying the Specific Relief Act does not apply anymore, because under the present Companies Act in Sri Lanka, you can straight away get that in a pre-incorporation contract ratified by the future company, but within a stated time or within a reasonable time period. Then of course the liabilities rights and liabilities under that pre-incorporation contract would vest upon the future company. Therefore, now we are coming to the conclusion of the answer. If these warranties are breached, the promoter will be liable to pay damages to the other party. However, if the company enters into a new contract with the other party in the same terms as per the pre-incorporation contract, without ratifying the pre-incorporation contract, the promoter's liability will be discharged. Otherwise, the new company has to ratify the pre-incorporation contract either within the stated time period or within a reasonable time period as per the Companies Act. So that is how you must arrive at the conclusion of that answer. Now, in this next question, again, now it's a part B question that carries 2.5 marks out of 10 total marks for that question number 5. Now the question is, Mr. Silva, a director of ABC Company Limited, has reliable evidence that the company unable to pay its debts when they are fallen due. Required to explain the duty cast on a director of such a situation under the Companies Act number 7 of 2007. Now the question is where Mr. Silva, a director of ABC Company Private Limited, has reliable evidence that the company unable to pay its debts when they are fallen due. What you are required to do is to analyze the duty casted on a director at such a moment. Now some students might mistake as to this question, how it is being posed. Some might think that this is a question that asks you to write on the possible scenario of a winding up. No, this is not a winding up matter. When a company has reliable evidence that the company is unable to pay its debts, then the director of a company must conduct what we call the solvency test. So this is a situation where you must elaborate on the solvency test. So the answer is that the duty casted upon the directors in such a scenario is to conduct a solvency test of the company in order to determine whether the company can meet its liabilities and to see if it can survive solvently. Solvency is the ability of a company to meet its long-term debts and financial obligations. Because no shareholder in a company would want his own company to go bankrupt or that he becomes liable. So what that shareholder would want from a prudent director who has been appointed to the director board to conduct a solvency test and report to the shareholders whether the company can exist solvently. So solvency is the ability of a company to meet its long-term debts and financial obligations. So that at least when you conduct a solvency test, you can be confident whether the company can run for the next year and likewise subsequent year, successive year. Solvency is essential to staying in business as it demonstrates a company's ability to continue operations into the foreseeable future. While a company also needs liquidity to thrive and pay off its short-term obligations, such short-term liquidity should not be confused with solvency, because sometimes you may require taking of loans as a short-term means of meeting the company's liabilities and business efficacy rather than closing down the company. So in a solvency test, if you see that the company is unable to run with the present status of the financial situation, rather than going into a liquidation, you can think of obtaining certain loans and still as a short term solution, and in long term you gain for the company. So, solvency should not be confused with short term liquidity, having liquidity for the company. A company that is solvent will often enter bankruptcy. A company that is insolvent will often enter into bankruptcy. That means that when a company cannot really survive, even with short term solutions, and the directors' prudent observation of a solvency test would show or prove that the company cannot survive even with short term solutions in the long run. So, therefore, a company that is insolvent will often run into bankruptcy. A company satisfies the solvency test if the company is able to pay its debts as they become due, what we call the cash flow test. With the cash flow you determine that, and the value of the company's assets is greater than the value of its liabilities or debts, what we call the net assets test. The distributions covered by the solvency test include dividends, share buybacks, tender offers and other share redemptions. So, you have to look at all these areas in conducting a solvency test. Though this is not an exhaustive list of all methods which a company may distribute assets to members. The board of directors must approve a certificate after conducting the solvency test. The board of directors must approve a certificate stating that, in the opinion of the company, will immediately after payment of dividend distribution satisfy the solvency test, and the grounds for that opinion. If the directors see that the company can solvently exist and progress or go on, then the directors must present that certificate to the shareholders and also must sign and state the grounds for that opinion. The certificate must be signed on the board's behalf by at least one director. It is not required to be signed by all the directors of the company, but signature of at least one director is sufficient. A distribution made to a shareholder at a time when the company did not satisfy the solvency test may be recovered by the company from shareholders subject to certain conditions. Where the distribution cannot be recovered from the shareholders, the directors can be personally liable in such a situation. That is because the directors have failed in their duty to do a proper analysis or judgment with regard to the solvency of the company. So, corporate solvencies happen because companies become excessively indebted. Invariably, the shareholders, directors and employees' liability is limited to the amount of their investment. So, against commercial creditors, they can lose no more than the money they paid for shares or their jobs. Insolvencies become intrinsically possible whenever relationship of credit and debt is created, as frequently happens through contracts or other obligations. As held in BNY Corporate Trustees Services Limited versus Eurocell, English law draws a distinction between a debt which is relevant for the cash flow test of insolvency under section 123 of the English Companies Act, and liability which becomes relevant for the second balance sheet test of the insolvency. A debt is a sum due and its quantity is a monetary sum. easily ascertained by drawing up an account. By contrast, a liability will need to be quantified, as for instance with a claim for breach of contract and unliquidated damages. So, the balance sheet test asks whether the value of the company's assets is less than the amount of its liabilities, which is a very important question, taking into account its contingent and prospective liabilities. As per section 57, a company, 57 of the Companies Act, a company shall be deemed to have satisfied the solvency test if it is able to pay its debts as they become due in normal course of business, and the value of the company's assets is greater than the value of its liabilities and the company's stated capital. In determining whether a company satisfies the solvency test, the board shall take into account the most recent financial statements of the company and shall take into account the circumstances the directors know or ought to know which affect the value of the company's assets and liabilities, and may take into account a fair value or other method of assessing the value of assets and liabilities. Now, in conclusion, I also want to draw the attention that it is the duty of a director to take necessary measures at times of insolvency. According to section 219(1) of the Companies Act, a director of a company who believes that the company is unable to pay its debts as they fall due shall forthwith call a meeting of the board to consider whether the board should apply to court for the winding up of the company and the appointment of a liquidator or an administrator, or carry on further business of the company. So, this is where they come into that determination. Section 219(2) further states that where a director referred to in subsection 1 fails to comply with the requirement of that subsection, and at that time of that failure the company was unable to pay its debts as they fell due, and the company is subsequently placed in liquidation, the court may, on the application of the liquidator or a creditor of the company, make an order that the director shall be liable for the whole or in part of any loss suffered by the creditors of the company as a result of the company continuing to carry on its business. That is a failure on its duty of the director to conduct a proper solvency test and arriving at the proper determination whether that company can pursue mainly on the balance sheet test. This would mean that if he fails to do so and continues the business, and as a result if the company is liquidated, the director is liable to creditors personally. Now that is the danger. As per section 219(3), if at a meeting called under subsection 1 of the board does not resolve to apply to court for the winding up of the company and for the appointment of a liquidator or administrator, at the time of that meeting there were no reasonable grounds for believing that the company was able to pay its debts as they fell due, and the company subsequently placed in liquidation, the court may, on the application of the liquidator or of the creditor of the company, make an order that the directors other than those directors who attended the meeting and voted in favor of applying to court for winding up of the company and for the appointment of the liquidator or an administrator shall be liable for the whole or any part of any loss suffered by the creditor of the company as a result of the company continuing to carry on its business. So, this is how we must conclude the question. In starting the answer, you must clarify the solvency part, and in conclusion you must say how the winding up affairs could be undertaken by the company and the director is obliged to do that, so that he overcome being personally liable. So, here we come to the end of the part B of question 5. Now, then I would like to take the other one, C, also consisting of 2.5 marks. There Mrs. Kanti, the secretary of XYZ Company Limited, has entered in following transactions on behalf of the company. First, to purchase required stationery of the company, and then to borrow 100,000 rupees from a creditor of the company. You are required to explain the legality of these transactions by considering the legal position of the secretary of a company. So, now what the question is on the legality of a secretary's action. Now, you know who is a secretary, but let us first give some clarification in our answer. Who is a secretary? Company secretary. According to section 221 of the Companies Act, every company shall have a secretary. I mean to say a company secretary.